This is Michael Popok, and it's time for Legal AF After Dark. Donald Trump, when he loses appeals, he likes to lose more than one way. He loses first with a 3-judge panel in a federal court about things like gag orders, and then he loses again when he asks for a full rehearing in front of all the judges of the Court of Appeals, in this case, all about Judge Chutkan's original gag order, which remains in place in the D.C. election interference case, as that case remains stayed, waiting another D.C. Court of Appeals ruling on whether he has presidential immunity for his criminal conduct while in office. Confused? You won't be. If you watch Legal AF, we unpack it all. Here's a clip. Let me frame we don't spend that much time on it, but I'll frame the D.C. Court of Appeals issue, and then I'll turn it over to you to wrap it up, Karen. So as most people, I hope, recall, there was a lot of gag orders that were being imposed on Donald Trump because of his bad behavior and conduct. We have the ones up in New York, with the New York Attorney General case with Judge Engoron, a couple of gag orders related to Donald Trump, which he violated and had to pay a lot of fines to the court. And then Judge Chutkan had sort of had enough, and Jack Smith, special counsel in the D.C. election interference case, which is currently on ice, awaiting, and boy, are we tapping our foot here on Legal AF, waiting for the D.C. Court of Appeals 3-judge panel to make their ruling. We don't really know about whether Donald Trump has presidential absolute immunity from criminal conduct while he was in office. Just saying it out loud, even, I would think our Legal AF's law students are all like, how could that even be a thing? And we don't think it is. And we're just kind of perplexed a little bit while we're waiting around for Judge Pan, Judge Childs, and Judge Henderson to get together and vote and write an opinion. An opinion that, frankly, I thought was going to take about 4 days, given the fact that every one of the justices that have ever touched the issue has indicated that they think it's important from a public policy and a justice standpoint that the trial of Donald Trump on the issues in the D.C. election interference case go to trial before November. Well, then hurry up and write the decision. It doesn't take that long, but they are taking that long. And in the meantime, the trial level activity is virtually stayed, meaning we've lost the March trial date. Just to manage expectations, there's not going to be a first week in March trial of Donald Trump at all, based on the recent rulings by Judge Chutkan. If it's an April trial, that would be great. May is probably more likely. Still enough time. But then, of course, the May trial date collides with Judge Aileen Cannon, who's been holding a table for Donald Trump allegedly in the obstruction and espionage case in Mar-a-Lago. So you got all these things going on. In the meantime, Chutkan gagged Donald Trump. The gag order is still in place, even though the case is stayed. Even though the case is on ice, awaiting this D.C. Court of Appeals ruling, the gag order is in place. And so far, sort of, kind of, Donald Trump hasn't violated it. And if he did, Jack Smith would file something, and that, the judge has said, she retains jurisdiction to continue to enforce. Donald Trump didn't like the gag order that Judge Chutkan imposed, that a separate 3-judge merits panel of the D.C. Court of Appeals did a little editing, but the heart of the Judge Chutkan gag order in place and affirmed by that 3-judge panel. And because Donald Trump, I guess, thought he would get a majority of 12, which was virtually impossible. And I said this on a hot take, and I said it to Ben, and Ben didn't agree with me at the time, which I will remind him on Saturday, because there was already 3 judges that were against it. And so, because it was unanimous. And then that left 9 left, which means in order to get the majority, he had to get, 4 more out of the remaining 5 or 6. He had to get 4 out of the 6. And I just didn't think he was going to be able to do that, even if they got to the merits of the argument. But he can't even get to a 12-judge panel for rehearing because, and I'll turn it over to Karen.
Because in a very short, brief order, the entire panel basically said, upon consideration of appellant's petition for a rehearing en banc, the response thereto and the absence of a request by any member of the court for a vote, it is ordered that the petition be denied, which basically means that nobody asked to to dissent. Nobody asked to be heard. Nobody asked to do anything other than just denied. I can't remember. Somebody says there was a judge, a judge's favorite. There's a famous quote from a judge that is, "I have two words to say to your request: denied," which I thought was hilarious. And that this is just a massive smackdown.
It's a huge blow, because not one of the 12, we know the 3 that voted in the merits panel were not going to vote for reconsideration at the 12 judge panel. So take them off the board. Of the remaining 9, he needed to get a total. He has to get a majority to even consider having the en banc, and then they have the en banc, and then they have to vote again to see, based on the merits, whether they're going. He couldn't get 2 nickels to rub together. He couldn't get one judge to say, "I think the 3-judge merits panel got it wrong," which is no surprise, because Judge Millett wrote the opinion, and she's very well respected. Again, one of these short list Supreme Court people, as a lot of them are. It's the feeder, the DC Court of Appeals, as we've said before, is the feeder program, sort of the minor leagues for the United States Supreme Court. Many of them get elevated to the United States Supreme Court. That's where Ketanji Brown Jackson came from. That's where many of them came from, frankly. And so, but that's another resounding loss. This is the strategy that Donald Trump, that's giving strategy a way too big of a heavy lift there in the sentence. The strategy of Donald Trump, I don't know who the strategist for Donald Trump is. Boris Epshteyn seems to be the one that forces Donald Trump, or reinforces with Donald Trump, that he should file these ridiculous lawsuits that end up getting Donald Trump sanctioned in Florida and in New York and different places. And then he's got this other group of appellate lawyers like John Sauer, who's not very good. He was the one that argued the presidential immunity case, the one that got all caught up and started to stammer about whether Donald Trump could order SEAL Team 6 to take out a political rival or not. If would that be okay? That was the question there. And you figure he'd be prepared for something like that, but he wasn't. And so Trump, because nobody wants to work for Trump, that's a very good lawyer, does not have a brain trust around him to help him make decisions. Like, if I were in his camp, which one disclaimer, I would never be working for Donald Trump. But if I was, I would never take an en banc decision, an en banc request for consideration. Now Donald Trump has got a harder case because now the United States Supreme Court and John Roberts, who would be the first judge on the first stop on the train, if Donald Trump tries to appeal the GAG order, I want to turn this back to you, appeal the GAG order to the United States Supreme Court through John Roberts, they already know that not one of the 12 people that are their colleagues right below them thought it was worthwhile to change the decision. So let me ask you, do you think Donald Trump takes this on appeal to the United States Supreme Court or tries?
Only because I think his trial strategy is, in all his cases, is to throw shit at the wall and to see what sticks. And so he's just throwing everything out there because some things will delay if he can get any traction, if he can just get any delay, because he doesn't really want to go to trial on any of these cases. He just wants to play the victim and try to get himself elected president so he can dismiss all these cases and never face any justice whatsoever. So his strategy is to muck up the works. He's got terrible lawyers who, I shouldn't say, some of them are terrible lawyers who don't know what they're doing. And if in some ways that plays into his whole strategy, because they're just mucking up the works. And that's what he wants to do. He doesn't want to win on the merits. But I have 3 things to say. Number 1, WTF is taking the DC Circuit so long to rule on presidential immunity. I mean, they should have had that decision 2 weeks ago, when the day after that they heard that case. And unfortunately, because it's taking time, now it's playing into this whole thing about the case not going and this trial not going. And I think that the Judge Chutkan sees the writing on the wall that this case isn't going, because she just scheduled another Jan 6 defendant, not Donald Trump, but somebody else, his trial to start April 2nd. And so if she doesn't think this case is going anytime in March, or she would have not scheduled that case, because the federal court trial dates are real. It's not, again, not like state court where it's sort of a suggestion and we'll see what happens, and they get pushed and pushed and pushed. Trial dates are real in federal court. So she knows it's not going in March. And this also means she doesn't think it's going in April. So that made me really kind of sick to see that. And then number 3, I'm reading the live chats. Jordy did not have a baby. Everyone's saying that Jordy had a girl. Jordy has not had a baby yet. So still on baby watch, but I just thought we should get that out there because I've seen lots of people saying it.
I agree. Wrong on many of those counts related to Jordy. We'll leave it at that. You're right about Chutkan, because I think I did a hot take on this. She buried in her order on the motion that Donald Trump brought for contempt against Jack Smith, in which she sided 95% with Jack Smith and just gave a little ice and winter to Donald Trump about future motions that deal with substantive issues that need to be briefed before the judge will even allow them. She said, I don't expect, and this is different than I had actually thought. The judge said, I don't expect, and I don't think that Trump and his team are preparing for the March trial. So, and I said, and she used her own quote, it's always great when judges quote themselves. I said that I thought there was, if 7 months was available for real preparation, I thought that was sufficient time. But it's not going to be 7 months because we've lost a month, or we're up 2 full weeks of the case being, more than 2 weeks of the case being stayed. And so it's almost a month since the appeal was filed, which is when she stayed it. It's 2 weeks since the oral argument. It's 4 weeks plus the case has been put on ice. And therefore, even under Judge Chutkan's principles, there's not enough time for Donald Trump. And so I wasn't surprised when she said that. Then I wasn't surprised when she's already filling up her dance card for April with another case. But I don't know what's going on. It's tapped. I have a theory. Ben and I have kicked it around. I think I kicked the rock around with you a little bit too. That Judge Pan, who's going to write the decision, I believe, she's the one that came up with, and so masterfully came up with. Talk about a sniper. She took out John Sauer in about 2 seconds flat with her SEAL Team 6 question to him. She either wants a 3-0, and she's having trouble with Henderson, who's the George W. Bush appointee, who seems to have her own unique interpretation of presidential powers and executive privilege, as expressed in some other cases, or it's just taking them longer to write the decision. I think they've already polled and decided. I'd be shocked if Childs and Pan aren't already haven't already decided against Donald Trump in their minds, and now they're either trying to get Henderson to come along for the ride and not dissent because it's such a momentous issue, or they're hung up about the jurisdictional issue, which was raised not by the parties, but by amicus, friends of the court brief, about whether the court has jurisdiction at all, which is an easy off-ramp to say, we don't, and this is not an appropriate interlocutory or middle of the case midstream appeal. You got to wait till the end of the case. It's not that kind of immunity as expressed in the United States Constitution, because presidential immunity is not in the United States Constitution. Mm-hmm. It's judge-made. It's common law made. It's from a line of precedent of the United States Supreme Court, dating back to 1807 or whatever the argument is. So there's a struggle that we're not privy to that's going on behind the scenes. I would assume that any day we've been saying this for 2 weeks, any time this week or next week, we're going to see the decision, and then there's going to be an immediate status conference with Judge Chutkan. She's going to call the lawyers back in and say, we lost a month, but I want to set this trial for, and she's going to say it. She's going to say May 1 or whatever she says, because these Jan 6 trials don't go that long. Even though she set that April trial, I mean, unless they're the Oath Keepers or the Proud Boys, they don't go that long, especially if do we know if it's a bench trial, a Karen, or jury?
No, it's a jury trial. It's criminal.
Right.
And, but I agree with you. They're probably arguing over one portion of how they're going to rule, right? It doesn't necessarily mean the overall question of presidential immunity is really what's holding them down or holding them, keeping this back from being published. It could be one particular issue within the greater issue. But the problem with that is then we're losing the forest for the trees, as they say, because this is a game of inches, right? This is Donald Trump. Every day, every week that goes by that these trials don't happen, you get closer to the election, and the harder it's going to be to hold him accountable. Let's say he's convicted, but he's up in all the polls. He's definitely the nominee. You really think that a judge is going to put him in prison at that point and sentence him and prevent him from the actual election? I mean, every day that goes by that he is not held accountable, that there are delays, is every day that we get closer and closer to never holding him accountable.
Yeah.
And so that he's winning. Even if he loses each argument, he is winning because these cases aren't going. And thank God for my old office, the Manhattan DA's office, because on March 24th, in the Stormy Daniels election interference case, the very first time he engaged in election interference, my old office is going to say my three favorite words that I loved to say, which is people are ready, and they are ready for trial, and they are going to go. And thank God for my office. Everybody who's like, why is that the first case? Why are they bringing that case? Oh, who cares? Blah, blah, blah. Guess what? Manhattan DA's office, once again, is going to be the office that brings it. And it's the only office that's going to do it.
They were the first to indict. And so, in a poetic justice, Alvin Bragg, who took a lot of crap, including being interviewed by you and taking crap in whatever chats we had at the moment. I think there's a certain cosmic justice to him being the one that brings the first actual criminal trial against Donald Trump, having brought the criminal trial against the Trump Organization. Well, if you like that, lawyers talking about things where they know what they're talking about, then you'll love Legal AF. The title is exactly what you think. We do it on Wednesdays. We do it on Saturdays, 8 p.m. Eastern Time. One place, this channel, this station, MeidasTouch, YouTube, Legal AF, and then on audio podcast platforms of your choice. If you know about us, that's great. We appreciate you being part of our audience. Take that clip, send it off to somebody in your life, one of your loved ones, somebody that you're close to, and ask them to check us out. If you don't know what I'm talking about and have never heard of Legal AF, I'm Michael Popok. That was Legal AF. And until my next hot take and my next podcast, this is Michael Popok signing off.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.